Thanks for the lovely introduction. And thanks to everyone for staying for this last presentation and the last session. Of course, thanks to Dr. Fuchs and Ira for inviting me again. So this is my second time here. I was here for the first time I checked, 2018, where I talked about the same topic. And what I can say is that things since then have moved on to an extent, but for an academic like myself, not fast enough. And I will talk about the law reforms as well. I think, sadly, I might not help your actual practice that much because there isn't much clarity that I can share with you, unfortunately. But I'm also happy to hear your views and practices. And I've heard some interesting developments in Denmark, for example, that could be that I should look into, and I haven't. Also, what I wanted to add about that Portuguese tool, if that's based on machine learning and AI, I would be very careful in how you use it, because I'm sure you've come across the cases in the US where ChatGPT and similar services have invented cases and the lawyers were penalized for that. So there are issues of hallucination within these models. And even if you get the usufruct adapted or however in the Netherlands, I would advise that you check that you use your knowledge and common sense, because these systems are just predicting, they're not understanding or knowing anything substantive as human beings. So moving on to my presentation, there will be a lot of things here. I might skip over the purely academic theories that I will briefly mention and move on to a more practical stuff, but there will be some of that, some conceptualization, then an overview of certain select jurisdictions as to how digital legacy has been already handled in case law or statutes, and then some empirical findings from my own research, very briefly, from the UK, well, again, not member of the EU, and some suggestions and conclusions, and the law reform, and a very interesting project that some of you are aware of, and some of you might find out and would want to participate in as well. Okay, so digital assets and digital remains. There have been definitions now already in some legislation in various contexts with regards to securities, for example, or with regards to digital currency, etc. But in the context of succession, I've tried to define it, as you can see here in my earlier research. But what we found in this area of research is that digital legacy is perhaps not the best term to be used here, and even less digital assets and even less digital property, to include everything that is out there left by the deceased in the digital realm. So what we use in research, and it's odd, I know, for practitioners, is digital remains. And these remains include digital assets that are quite clearly akin to property and could be seen as forms of property, but also personal data that I know you probably all work with GDPR because you have to, but I'm not sure how much of experts you are in that particular area of law, but also in personality rights, image rights, copyright, moral rights, everything else that this really everything that is relevant in this area, because there is so much that relates to the deceased identity, their dignity, their privacy, their personality, and that is left online. And increasingly so with the AI and, the ability to leave your chatbot, your avatar post-mortem that will live on for a certain period of time, and for you to achieve so-called, as we call it in, again, research, digital immortality in a very, very limited form. So digital remains, we argue, is a better term to be used, and this is one of the proposals in our project in the European Law Institute that I will mention shortly. It is radically different from anything that is out there, I understand. And I will take the criticism as well from, very traditional and doctrinal perspective, but I'm happy to engage into these conversations. What also I think is very relevant here is the concept of post-mortem privacy, because I did mention that it's not all just about monetary assets. There is a lot of personal data. There are a lot of communications, identity-related remains out there that relates to secrets, memory, reputation, dignity of the deceased person. And for that, we use the notion of post-mortem privacy that unfortunately is not recognized as a concept, as you probably very well know, in law of any country in the world in this form, at least. There are some forms of recognition that I will mention related to personal data, which is, in my opinion, good news, but the comprehensive concept of post-mortem privacy that I propose in my research hasn't been recognized, and I argue should be recognized, and this is my long-standing strand of research for the past nearly 15 years. I go even a step further to propose this sci-fi concept of post-mortal privacy, which includes the aspects of immortality in the digital realm, and this is even less applicable, so I won't get into at least for the law of our respective countries as it stands, the positive law. So what I can report, and something that you again, given your practice, may or may not be aware, is the European Court of Human Rights jurisprudence on post-mortem privacy. They're not using the term, but yes, there is a Danish case that's very interesting, and where the court established, and this hasn't really been revised, that there isn't a direct protection for the deceased privacy under Article 8 of the Convention, but there could be an indirect protection if through, so for example, violating the memory, dignity, reputation of the deceased, you violate their family members, surviving family members, so Article 8 and the right to protection of family and privacy. So it's sort of an indirect protection, not a direct protection that I would like to see, but jurisprudence is evolving as its technology is as well. So we shall follow this. There's a series of cases that I've also mentioned here. So if someone is interested in this, well, for me, very interesting area, then you can look those up. In terms of personal data, I have mentioned GDPR, that we all know. GDPR is the most infamous piece of law anywhere in the world. And when I talk to my students or anyone else, it's like all techies, computer scientists that I work with and others in research projects, everyone has heard of this statute. There isn't a single, I think, person that hasn't, which is good and bad. Personal data is not protected at the EU level. Personal data of the deceased, sorry, not personal data is very well protected, but personal data of the deceased users is not protected in GDPR. However, going back to recitals, there is an interesting recital 27 in GDPR that says the member states might provide for rules regarding protection of deceased personal data. And maybe some of you here in the room, especially Italians, the Danish, Bulgarians, not the Germans, the French, will know some of or have heard of some of these protections, where member states have decided to either, for example, extend the consent of the person for 30 years post-mortem, or allow for the exercise of certain rights under GDPR, the right to access, the right to deletion, the right to data portability, that can be exercised by a personal representative or family member's heirs. So this is where you, in your practice, might have maybe come across something like that, that someone wanted to exercise a GDPR right and access the deceased account's data. Maybe you have, maybe you haven't. I would be interested to hear, so please do feedback that in your question or later in the break. So I've listed some examples here, and I will talk about France in a little more detail. Italy has a very, very interesting model of the extension of the protection for the deceased data that we are working on within the ELI project to sort of adapt and maybe propose as one of the solutions. We'll see how that goes. We'll have a huge opposition from some of the other countries, but yes, work in progress. So when we categorize these regimes that apply to digital legacy and digital remains that are there and regulate this to an extent, and I said that no country regulates it comprehensively. So We can identify patrimonial or succession regime, which for you is probably, the best one because you are aware and you are very familiar, you work with that, so it's great. So we've got Canada, Catalonia, and Germany. And Germany has had a very interesting case that I will mention involving Facebook that you probably have heard of. Yes, I can see some nods. So please do react or mention something good to gauge the audience as well. Quasi-property regime in Estonia, sort of similar to intellectual property, and again, involves also a protection of personal data. And then what we call post-mortem privacy regime, again, for academic purposes, and I will refer back to France and the Digital Republic Act, where we identify protections of post-mortem privacy, also very, very strangely and ironically in the US. And I say ironically because we probably know, all of us here, that their protections of privacy and personal data is very, very limited. They've got First Amendment. They don't have a similar amendment for the right to privacy. And they have a very patchwork protection of personal data in the US. However, for post-mortem privacy, they've got something called RUFADA, which is Unified Fiduciary Access to Digital Assets Act. I've remembered it after so many years. And it does prioritize deceased wishes expressed about in personal data inter alia, and these wishes can be expressed through technology or the will or terms and conditions. So this is a very strange development for the US. It's again based sort of on a property paradigm, but the consequences are that the deceased has a right to dispose of their personal remains and personal data through technology. And I'm not sure how many of you have heard of Google's inactive account manager, good, or Facebook's and Apple's digital legacy account, excellent. So those are some of those ways where the deceased can decide, I leave, and if you use Google inactive account manager, you can leave so much. You can leave your emails, you can leave your photos, you can leave your personal communications, and you can imagine as practitioners what this means. You are leaving effectively not just personal data, but copyright, potentially other rights that are within that account, and you are leaving that to beneficiary. And that beneficiary can be your lover, your ex-boyfriend, your friend, someone else, not your heir, not your personal representatives, like anyone who has any sort of a title or a right, but someone that you've designated in Google and just left their email. So you can see the conflicts that can rise, and I'm not sure if anyone has come across those conflicts, but it's a very interesting, at least as a hypothetical. And there are also countries with no response, sadly. One of them is England and Wales, where I work and live. And the problem here is that the personal data of the deceased is not protected at all, because the definition of personal data includes the word living. Protection of the data of the living individuals excludes the deceased completely. And then there isn't anything in terms of the law reform, unfortunately, apart from digital wills at the moment going on in the, not the UK, I can't say the UK is because Scotland is very different from England and Wales in this area, so England and Wales. So what, going back to that, well, home jurisdiction in a way, although it's not technically, it's second home. There is a really, really old Wills Act that, of course, is not entirely helpful for digital legacy. And there have been a couple of cases. The Molly Russell case involved, again, the access similar to the German Facebook case to a deceased girl's Instagram account, where her family fought quite fiercely against Instagram, Meta, and Facebook to access her communications. There was a coroner's inquest, and it resulted in a law reform where in the digital online safety act, there is a provision that allows parents now to access personal data of the deceased children for various purposes. The Rachel Thompson case is also quite important with limited significance because it is a Central London County Court decision from 2019 where Rachel Thompson got access to her dead partner's Apple account to acquire photos and videos, family photos and videos there. And in this case, the judge called for law reform, saying these cases will be coming up more and more in the future, and we would like to see some clarity. We don't really have any clarity here in England. I mentioned that the living individuals are defined in the Data Protection Act, and I've already mentioned the disclosure information about the use of services by deceased child users that is now in this very fresh Online Safety Act that is similar to the Digital Services Act in the EU, in a way, in its scope and aim. So the Law Commission has been promising in England and Wales to reform this area and help, well, not me, but solicitors mostly and practitioners there. And it was a question of sort of, this is too difficult. We can't resolve this within a Wales reform. We have to consider contract law, property law, personality, privacy, protection of personal data. So we will leave this for a separate reform. And they said that in 2017. Again, 2023, they said a similar thing. We have to have a separate reform for this. And they again started a consultation on the law, on the reform of law wills, and considering digital wills, but just digital wills as an instrument, nothing substantive in this area. And again, they sort of brushed this whole area of digital legacy under the carpet and said, we'll leave it for later. So they keep postponing the law reform when I communicate with them and suggest that this is now quite urgent, and there's quite a lot of helpful provisions across Europe in this regard. They promise that they will maybe prioritize that in the next program. So not much to report. In Germany, interesting developments. Again, I don't have time to go into too much detail on this case, but it's a well-known case from that reached the Federal Court of Justice about Facebook and the access again to the deceased girl's account by the parents, where there was a disagreement between the first, second instance court and the Federal Court of Justice. The argument at the Court of Appeal, the second instance, was in short that privacy of communications and secrecy of communications prevented the disclosure of personal data included in one's social media account. In Germany, the Federal Court of Justice disagreed and applied the principle of, that you know much better, the universal succession to this case as well, saying that even highly personal contracts like the contracts with social media are covered by the principle of universal succession, and the parents would step into the shoes of this girl and inherit this contract. So they were granted access to the Facebook account. In France, interestingly, there are sort of two main categories. There are parallel, and one relates to what we call digital assets that are more property-like, like crypto assets. They are treated as movable goods, and they're subject to civil code. So there has been a lot of writing about this. This is not my own finding, but finding from colleagues from France, academics and practitioners. But there's also a regime that is applicable to personal data, which is very, very interesting, established by the Digital Republic Act 2016, where the deceased, in short, can leave specific and general directives as to what happens to their personal data on death. And for me, this is very interesting because that's something I've been arguing for many years, and it sort of reinforces this concept of the protection of autonomy, testamentary freedom, and the protection of one's personality, if one, of course, chooses to do that. And there is a bit of a problem with the implementation of these directives, because the Act said that CNIL, the data protection regulator in France, will have to specify this in, I think, decrets, if they're called, Diane, you can correct me if I'm wrong, but that they would need to specify what happens and where they're registered. And the last time I checked, that hasn't happened. So there is a problem with implementation. What we have actually mentioned already, and some of you have heard, which is very encouraging, is the technology solutions. So what we call in-service solutions, where individuals can actively engage with their digital remains and decide what happens to them on death. And Facebook, Instagram have certain options that I've listed there. Google has this inactive account manager we talked about. There's also Apple Legacy Contact. There's a one on LinkedIn. So increasing number of service providers introduce this that I've already said can be problematic, especially for you practitioners, because these can clash with, actual law and legal provisions and heirs and their rights and interests. Okay. I've got a bit more time left, I think. So I will just briefly present you, and this is again, a research project, but I think it's interesting just to share some of the key findings where we talked to solicitors and barristers in the UK, US, and Canada to an extent, to ask, through semi-structured interviews, to ask them about their practices around digital legacy and to how they navigate this complex and unclear areas, especially there. And this is what we found in terms of the themes: the lack of awareness within the profession, but also, of course, more so within the general population, because the clients don't really mention those when inventory is being made, and the clients are not aware that they should be talking about that if they're not prompted, and there's a huge problem with awareness. There's also a problem with taxonomies, understanding of the terms, understanding of. And this is a big ask, because if you consider these digital assets and digital remains, you don't only have to be experts in succession and property, or have to know a bit about contracts, about data protection, about intellectual property, personality, etc. So I understand it's a huge mess to navigate. And even as an academic who's worked in this area for quite a long time, it's very, very complex. There is, of course, a problem that we recognize with platforms and tech companies that prevent access, misbehave, make it difficult to the practitioners and clients to access and communicate with them. There are limitations of current practice in that solicitors report that they don't engage with this area sufficiently, because they're also afraid of liability, because there's the lack of legal clarity in the area. So some of them demonstrate certain level of creativity, which we found also very interesting, but others were reluctant because they were concerned with the lack of clarity. And a predominant theme that we found was change. We need a law reform, we need clarity, we need legal provisions, or a case. But a case is a problem because you would need a big shot celebrity or someone to engage with a high-level case that will reach second instance court or something similar, and clarify that a little bit. And that person would have a huge amount of digital assets and remains and personal data, for example. So that findings I've already mentioned. Oh yes, I should just add that we also interviewed some regulators, and they don't consider this area to be a priority, and this is what we also expected. But I think increasingly this sentiment is changing. So hopefully that there will be some law reform coming up soon in the UK, but potentially also in the EU. And this is what I'm going to talk about shortly. So these were findings that I will skip here, but I will talk a bit more, and in the few minutes that I have left, about the EU-wide approach. So I did mention the European Law Institute's project on digital succession and digital remains that is headed by myself and Professor Antoine Eigenmann from Freiburg University, and includes 4 other colleagues both practitioners and academics on the team, and a wider range of group in advisory committee, in the MCC, et cetera. So we do welcome input and feedback from everyone, and particularly practitioners from across Europe. And our aim is, and the outcome is a difficult one, so to draft model rules / principles for the EU in this area. It's quite scary, given, of course, what you have discussed a lot across these 2 days, the differences between jurisdictions, between countries. And here we don't just have property and succession. As I said, we also have data protection involved in contracts and whatnot. So it's a big task, but we are optimistic, and we hope to produce something useful, and we'll see how that develops into an EU proposal. What I can say about the EU as institution, and that's something that I've just discussed this morning early after breakfast with someone from the DG Connect in the Commission in another event virtually. But there is, I'm sure you've heard of the European Declaration on Digital Rights and Principles from 2023. So it's just a declaration on digital rights that doesn't change anything in terms of fundamental rights, of course, and the Charter, but as they say, it restates some of the mostly political choices and important paradigms. And one of the articles there, Article 19, talks about digital legacy. And I was quite shocked when I saw it in the draft and initially, where they say the individuals in the EU have the right to determine their digital legacy, this is a weird phrasing for you, I'm sure, also for myself, and to decide what happens to their personal information and personal accounts. Okay. So they haven't consulted anyone that I'm aware of that works in this area of digital legacy, unfortunately. But when I asked the Commission about this, but just this morning, about how are they going to implement this, because there are also commitments attached to these digital rights and principles in the declaration. None of the commitments relates to digital legacy. So I suggested that they should work with us, and we have something interesting, hopefully soon to feed into that, and that would really relate nicely to this declaration and fulfill the promises, that the individuals will have the right to determine their digital legacy. So that's quite exciting. Also, the role of the legal profession here, of course, is invaluable. All of you here, everyone else, and there's a useful association that some of you may be members of, the Society of Trust and Estate Practitioners, STEP, with thousands of members across the world, and we work with them on research projects. They're also on the advisory of our ELI project, as well as the UNIDRA and other institutions. So hopefully there will be some clarity, and the feedback we will receive, I'm sure, will be very, very substantive, and there will be some change going on in this area. There are some other proposals that are mostly academic here. Some of them relate to harmonization at the EU level in terms of data protection, which would mean amending GDPR, which is, we understand, very difficult, especially if you just want to amend it for this one particular area of the disease data. There are also AI solutions that are being explored in various research projects, including mine. So just for you, this will be probably very shocking, and you would say don't do that. But using AI to interpret wishes of the deceased and their will. It's experimenting with scientific approaches. It's not going to be commercialized anytime soon. So it's interesting for us to explore how that could be done. Also, including the donation of posthumous data donation in the regime, as the organ donation, akin to organ donation regime, is something that we've been considering in the academia, and is a policy proposal. So all quite exciting. So I think I have exhausted my 30 minutes probably. And these are some references in case anyone is interested in reading some literature before going to bed and finding this boring literature to fall asleep. So thanks for your attention. I look forward to your comments from your experiences or any questions that you may have. Thanks very much for having me. This is my book in case someone is again interested in reading even more on the boredom. And it's a very untypical academic cover, I acknowledge. But yes, I had the freedom to use it on my monograph. Thanks very much.